This is 6 of 7 short lectures on alimony. Well, I should say one of them was not so short, but this one is fairly short. We're going to talk now about modification of alimony in a little more detail. Some types of alimony, as we've already discussed in other lectures, are not modifiable. If they are modifiable, it's based on the legal test called substantial change of circumstances. The court, when alimony is awarded, retains power over modification in those cases and in those categories of alimony that do provide for alimony modification. The power of the courts to modify it ends with the due date of the final payment of alimony. The court can enforce a missed payment, but cannot modify it if the due date has passed. The parties can agree that alimony is not modifiable, but if the law provides that a certain type of alimony is modifiable, and the parties have agreed to a type of alimony that is modifiable, then the court can still modify the award. This may ring similar to child support laws we'll discuss. Well, we actually discussed it already in the premarital agreements chapter. Similar to that concept that one cannot contract away child support, a person cannot contract away something that the law provides a remedy for. In this case, the ability to modify an award that is modifiable as a matter of law. Modification of temporary or pendente lite alimony is modifiable because it's not permanent in any permanent form, and the court can increase and decrease it up to the time of the final decision in the case. When the final order comes along, it does typically result in a modification, an increase or a decrease in the temporary alimony award. Sometimes health care is part of the temporary award, and maybe that will stop or increase or decrease. Attorney's fees. Most attorneys require payment when they represent the client. When a spouse cannot afford to pay the attorney fees, the court may award payment of the other spouse's attorney fees. Still, the need and ability to pay threshold legal question comes into play. The fees must also be well documented and reasonable. One of the termination of alimony issues that comes into play a lot today is cohabitation of the spouse who's receiving the alimony. There is a legal presumption that when a receiver of alimony cohabitates in a supportive relationship, there is need for alimony. There's less need for alimony. The possible reasons for termination are people holding themselves out to be married, the length of time they've been living together, how they pool their assets or income. Are they putting them into one account? Are they spending each other, they buying each other the groceries and paying the rent together, etc.? How much support is the one providing to the other? Has one performed a service for the other or the other's company or employer? Is one going to work for the other's company as the receptionist or as a business executive? Are they working together on something of value? Are they building a home themselves? Are they building a collection of trains? I don't know. Does contributions to real do they make joint contributions to real or personal property? Do they have any express agreements to share or support each other's property? And have they provided support to the other's children? Death is a cause for termination of alimony, and the only exception is lump sum. Now I'm going to say it, alimony, which remember is not really alimony. It's a property right, and it's not technically alimony, and it is vested in the person. What vested means is that once you've been given the right to have it, it's vested in you, in that person to have it. And that means it is a property interest that doesn't go away until it's all disposed of or used up, I should say. A person receiving a lump sum alimony would go to the probate court and file a claim because property division transfers will survive a person's death. But basically, alimony terminates on death. Alimony, in the real sense of the word, terminates on death, and there are no obligations on the part of the ex-spouse, or their estate, I should say, to pay any unpaid alimony that's not in reality a property settlement. The typical question as far as tax consequences is whether the payment of alimony can be deducted by the person making the payments, the payer. The person receiving it typically wants to know, do I have to report it as income on my tax return? The answer is that if it meets the definition of alimony, then it's included as income on the receiver's tax return, and the payer doesn't get a tax deduction for it like they do with child support. And this is all law. The laws related to is it definitely alimony get complicated, and that's why at the latter part of the course we're going to cover tax consequences and the family issues as one big ball of wax, because it's just a lot to cover in pieces. But for the purposes of this particular module, these are the points that you need to know.